Right now, the United States Supreme Court is weighing a legal challenge that holds the entire trade structure of the U.S. economy in the balance. This is not a theoretical debate. It is a direct confrontation between the judiciary and the executive branch in a massive $1.2 trillion showdown over presidential authority. At the heart of this conflict are President Trump's sweeping global tariffs, which are legally predicated on the International Emergency Economic Powers Act, or IEEPA, of 1977. This decades-old statute was originally designed for the president to take rapid action, like imposing sanctions or freezing assets, during genuine, immediate national security emergencies. Crucially, the law has never been used by any previous administration to impose broad, long-term tariffs, which are fundamentally a form of tax. The core question the 9 unelected justices must answer is simple yet deadly. Did the president have the legal right to claim the nation's perennial trade deficit constitutes an unusual and extraordinary threat under IEEPA, allowing him to bypass Congress's constitutional power to impose tariffs? If the court strikes down the use of IEEPA for this purpose, it instantly dismantles a cornerstone of his economic agenda, from negotiating leverage to the proposed tariff dividend. This outcome would force the Treasury into a multi-billion-dollar refund scenario for duties already collected from American companies and importers. The lower courts have already signaled skepticism, and even key conservative justices appointed by President Trump question the boundless nature of the power being asserted by the administration's lawyers during the recent extensive oral arguments. Over the course of the final decision, we will track the 3 central legal arguments used by the justices, the surprising ideological splits that have appeared on the bench, and the one legal plan B that means the tariffs, while perhaps fundamentally changed, may never truly disappear. The legal battlefield is centered on the International Emergency Economic Powers Act, a 1977 law that grants the president authority during a declared national emergency to regulate importation, but which was historically intended for specific actions like imposing sanctions or freezing assets of hostile states. The core argument against the administration is that IEEPA was never intended to facilitate a broad, multi-year global trade war. The challengers, a coalition of American small businesses, states, and legal experts, argue that this use fundamentally violates the Constitution's separation of powers. Specifically, the Constitution grants the power to levy taxes and duties, which tariffs clearly are, to Congress alone under Article 1. They contend that the administration essentially hijacked an emergency law to usurp this legislative power. The justices expressed profound skepticism during oral arguments. Justice Ketanji Brown Jackson, referencing the law's history, pointedly asked the Solicitor General how the IEEPA, which was created to constrain presidential power, could now be interpreted to grant unlimited power over the entire U.S. economy. This skepticism extended across the ideological spectrum, creating a conservative fissure as Justices Neil Gorsuch and Chief Justice John Roberts expressed clear discomfort with the power being claimed. They focused on the major questions doctrine, a principle stating that if the executive branch takes an action of vast economic and political significance, which a multi-trillion-dollar tariff regime undeniably is, it must have explicit and clear authorization from Congress. Since the word tariff is conspicuously absent from the IEEPA text, the administration's entire legal defense risks being invalidated by a doctrine that has been used to strike down major policies of previous administrations. This case is not just about trade policy. It is about whether a president can continually invoke the word emergency to unilaterally bypass Congress's clear constitutional authority to levy taxes. The final decision, expected as early as the end of the year or by next June, will establish a precedent that will reshape the balance of power between the White House and the legislative branch for decades to come, regardless of which specific tariff law is eventually utilized. If you found this breakdown of the Supreme Court's trade war helpful, then do not let the next one catch you by surprise. Hit that subscribe button now and turn on the notification bell. We track the biggest legal and market shifts the moment they drop, so you can always stay ahead of the curve.